You know, it's pretty much the classic neighborhood nightmare, right? A fight with your homeowners association. But this one's a little different. When a brand new roof started leaking, a homeowner's simple request for some documents snowballed into a full-blown legal battle. And the ending is probably not what you'd expect. Okay, so let's set the scene. It all kicks off with a monsoon in July 2021 that wrecks the roof on Robert Ochs's property. No problem, by September, the HOA gets the whole thing replaced. But then, just a few months later, the new roof is leaking. So understandably frustrated, Mr. Ochs formally asks the HOA for the paperwork on the repairs. And that is where things get complicated. So you can imagine, with water coming into his property for a second time, Mr. Ochs just wanted to see the details. What materials were used, what was the plan, but trying to get those documents, well, that turned into a storm all on its own. And this is what Mr. Ochs himself had to say about it. He's talking about a serious investment here, and he's on the hook for all the damage happening inside the unit. He wasn't just trying to be a nuisance. He really needed to figure out what went wrong with a major repair that the HOA was supposed to have handled. Now, this didn't just escalate overnight. He sent his official request on February 27th. The HOA manager even wrote back, saying she was working on it, but then, crickets. Total silence. He waited almost 2 months, followed up again on April 21st, and still heard nothing. So, just 3 days after that, feeling like he had no other option, he filed a formal petition. Now, Mr. Ochs wasn't just, firing off an angry complaint. He was strategic. He believed he had a very specific state law in his corner that made his right to see those documents totally clear. And this right here is the heart of the matter. It's an Arizona statute that seems pretty unambiguous. It says an HOA has to make all financial and other records available to a homeowner within 10 business days of a request. 10 days. Seems pretty cut and dry, doesn't it? So his argument was just so clean and simple. Look, the HOA paid the roofer. To approve that payment, they must have had the paperwork, like the scope of work. Therefore, that paperwork has to be an association record. And since they didn't hand it over in 10 business days, boom, they broke the law. Case closed. Or so he thought. But, as you can probably guess, the HOA's legal team had a completely different take. Their entire defense really came down to a single but very powerful argument about what those documents actually were. And this is where the two sides just completely diverge. Mr. Ochs is saying, hey, you paid for it, it's your record. But the HOA fires back, whoa, not so fast. Those are the roofer's business records, not ours. We don't have to go chase down paperwork from a third party just because a homeowner asks for it. Yeah, the HOA's lawyer basically said it all right there. They weren't fighting about the leak or the timeline. They were arguing that the very law Mr. Ochs was using simply didn't apply to the kind of documents he wanted. All right, so you've heard both sides. You have the frustrated homeowner with a pretty clear-looking law, and you have the HOA saying, no, not our records. So who won? Who do you think the judge sided with here? Okay, so after hearing from everybody, Mr. Ochs, the HOA's management, the administrative law judge went back, reviewed everything, and issued her final ruling. And in a decision that I think will surprise a lot of people, the judge sided with the HOA completely. Mr. Ochs's petition was denied. Wait, what? How is that even possible? The law seems so clear. Well, the answer is buried in the very specific nitty-gritty legal definition of what an association record actually is. So here's how the judge broke it down. She said the law only forces an HOA to provide records it already has and keeps in its ordinary course of business. Stuff like meeting minutes, budgets, that kind of thing. The roofer's detailed plans? That doesn't qualify. The evidence showed the HOA didn't actually have those specific documents when he asked. And here's the kicker. The law doesn't force them to go play detective and hunt down records from their vendors for you. So the final word from the judge was crystal clear. Since the documents weren't technically association records that the HOA had in its possession, that 10-day rule was never even triggered. The HOA, legally speaking, did nothing wrong. And that right there is the big takeaway for any of us living in an HOA. There's this tiny but incredibly important legal line between the records your HOA creates and keeps for itself and the records that belong to the outside companies it hires. Your legal right to see them is completely different. You know, this whole case is a powerful reminder that what feels like common sense and what's actually required by law can be two totally different things. So it kind of leaves you with a final question, right? Now that you know about this tricky distinction, would it change how you talk to or what you expect from your own HOA?